Welcome to the Duty to Accommodate People with Disabilities 101. Let's learn about the basics of what is the duty to accommodate people with disabilities, who does it apply to, and how does it work. My name is David Lepofsky. I'm a visiting professor at the Osgoode Hall Law School, and I'm also the chair of the Accessibility for Ontarians with Disabilities Act Alliance. One way or other, for several decades, I've been involved with the duty to accommodate people with disabilities. Back 40 years ago, when many of us were trying to battle to get the Ontario government to ban discrimination because of disability and to make it part of the Ontario Human Rights Code, way back then we were working on getting the duty to accommodate entrenched in our law. Decades later, thanks to the efforts of so many, the duty to accommodate now applies to employers, to service providers, to landlords, to those who make and sell goods and services right across Canada, whether they're in the public or the private sector. So let's learn about it. If you are a lawyer or a law student or a teacher or the owner of a business or a manager, or helping run or work in a government department, if you're a landlord, if you run a store or a restaurant, or work in a store or a restaurant, if you're involved in a public transit authority or a hospital, frankly, any organization that has employees or that provides goods or services or facilities to the public, this talk is for you. So let's start by talking about this duty that way back when very few people knew anything about, and now lots of people know about it, but far too many don't know enough about it. Let's try to bridge that gap. Now, this talk will focus in no small part on the situation in the province of Ontario where I am, but one way or other, these ideas and these principles apply right across Canada, and in other parts of the world you could probably see ways that you can benefit from this too. So where does the duty to accommodate come from? Let's turn it around. Let's not just talk about the duty of employers or providers of goods or services or facilities to accommodate. Let's also talk about the fact that people with disabilities have a right to have their disability-related needs accommodated. This in Canada is both a constitutional right in the Canadian Charter of Rights and Freedoms, Section 15, insofar as government or government-run programs are concerned, but it's also a quasi-constitutional or near-constitutional right where it's guaranteed in provincial or the federal human rights code, provincial human rights codes, or the Canada Human Rights Act right across Canada. Wherever the law guarantees equality or prohibits discrimination based on disability, the duty to accommodate is there, the right to be accommodated, and it's a central part of that right. Whether it's in those human rights codes explicitly, like in Ontario where it spells it out, or implicitly where courts have interpreted as part of the guarantee of equality and the ban on discrimination, it's there. You'll also find it in other legislation when they include anti-discrimination or equality clauses. For example, our national transportation legislation in Canada includes a human rights clause, and it has been interpreted as imposing a duty to accommodate on nationally regulated transportation providers. Other legal documents like collective agreements between unions and employers can include anti-discrimination clauses. And if they ban discrimination, that includes a duty to accommodate that can be enforced under the collective agreement. Similarly, if a professional code of conduct prohibits discrimination by members of that profession, that includes a duty to accommodate too. And finally, another source of the duty to accommodate in recent years has been the gradual development of accessibility legislation. In Ontario, we have the Accessibility for Ontarians with Disabilities Act, or AODA, federally the Accessible Canada Act, and certain other provinces have passed these or are developing them too. To the extent that these laws are trying to achieve accessibility, they are implementing or building on the duty to accommodate. So who has the duty to accommodate? Who has to do the accommodating? Well, this duty first arose and most often gets talked about in the context of employment. So, of course, it is a burden, an obligation on employers. But it doesn't stop there. As I said earlier, it also applies to the providers of goods or services or facilities to the public. So, schools, stores, colleges, universities, restaurants, public transit authorities, landlords, anyone who's providing goods or services or facilities, whether they're in the public or private sector, or whether they have employees. We lawyers can get caught up in debates over whether a particular employer or service provider is governed by provincial anti-discrimination laws or federal anti-discrimination laws, but one way or other, the duty to accommodate, it's there. Moreover, the duty to accommodate overrides all other laws that provide lesser protections for people with disabilities. The obligation in Ontario goes so far as to have the Human Rights Code explicitly says that anyone who does anything which directly or indirectly interferes with a right under the Human Rights Code, such as the duty to accommodate people with disabilities, they have violated the Human Rights Code, and they can be subject to proceedings. So even if you're not the person who has the duty to accommodate or not part of the organization that has the duty, if you do something that blocks someone from being able to accommodate, you could be exposed to responsibility under the Human Rights Code. Now, organizations can have more than one duty to accommodate people with disabilities at the same time. They can owe overlapping duties to multiple people. So, for example, a hospital owes a duty to accommodate patients with disabilities. It also has a duty to accommodate its employees and volunteers with disabilities. Some of the accommodations are going to be the same thing. If you need an accessible bathroom because of your disability, you need that whether you are an employee with a disability, a visitor with a disability, a volunteer with a disability, or a patient with a disability. It's the same bathroom. That bathroom, if it's properly accessible, will meet the duty to accommodate all of those people. Similarly, schools owe a duty to accommodate employees working there and volunteers, but also a duty to accommodate students with disabilities, and to the extent that they are part of the umbrella, they can have a duty to accommodate parents or guardians of students if the parent or guardian has a disability. What's the purpose of the duty to accommodate? It's important to understand the purpose of it because anytime an issue comes up about what it requires, we always look back to what the purpose is it's trying to achieve. Well, it begins with the fact that we live in a society which is overwhelmingly full of barriers against people with disabilities. Some of those barriers are physical barriers, can't get into or get around a building. Some are technology barriers. Some are attitudinal barriers. Some are bureaucratic barriers. There are information and communication barriers. But we live in a society full of barriers. And this is unfortunately because our society is overwhelmingly has been operated on the implicit assumption or presumption that it's there for people without disabilities primarily. So we get a one-size-fits-all society, excuse me, too often, and then people with disabilities have to come along as an afterthought and say, hey, wait a minute, I can't benefit from that program or service. Then the duty to accommodate is triggered. The goal of the duty to accommodate people with disabilities is to assure to people with disabilities the equality of opportunity to fully benefit from, be fully included in, and fully participate in the employment, the goods, the services, and facilities that are afforded and available to the public or to others. It maximizes the ability of people with disabilities to enjoy life, to contribute to our economy, and to be full participants in our society. Ultimately, it helps serve the goal of achieving a barrier-free, accessible society. That's the goal we see in legislation such as the Accessibility for Ontarians with Disabilities Act here in Ontario, or the Accessible Canada Act federally. The duty to accommodate is there to respect our individuality and our diversity. We are not all one-size-fits-all clones of each other. We have distinctive needs. For an employer, the duty to accommodate helps ensure that an employer can make a fair and accurate assessment of whether what an employee or a job applicant with disabilities can do and whether they're qualified for a job. For example, a simple example, if a person with a disability, if a person needed eyeglasses to read, you wouldn't size them up for a job in an office by saying, first take off your glasses and then let's see if you can do the job. They need the glasses. You want to get a fair assessment of what they can do? Let them wear their glasses. Now, let's turn from the purposes of the duty to accommodate to the benefits of fulfilling the duty to accommodate. It's important to be alive to these benefits as we then go through the principles of how the duty works and how to go about fulfilling the duty. There are multiple benefits from the duty to accommodate, for the right of people with disabilities to be accommodated. People with disabilities in our society are the minority of everyone. Everybody has a disability now, or has someone near and dear to them who has a disability, or will get one later as they get older. We're all bound to get disabilities, or indeed more disabilities, as we get older. So even if we don't need a particular accommodation in a school or a hospital or a store or a restaurant right now, we are bound to need one later on in life. And to the extent that organizations are able to effectively accommodate people with disabilities now, they will be effectively able to accommodate the minority of everybody. This duty to accommodate has other benefits. For the perspective of businesses, it gives them access to a broader pool of prospective employees. It helps them retain their existing employees, because the employee of today who has no disability can well become the employee of tomorrow who has a disability. Employers want to keep their employees around because they've got dedication to the company, experience, and knowledge. The more they're prepared to accommodate their needs, the greater their ability to keep them with working there. The duty to accommodate, when effectively implemented, also gives companies and organizations access to broader markets for their goods, services, and facilities. There's upwards of 1 billion people with disabilities around the world. That's one heck of a market. And if we only do one-size-fits-all goods, services, and facilities, that's a market that an organization is going to miss. The essence of the duty to accommodate is creativity and flexibility. And creativity and flexibility are core to the success of any organization, public or private sector, for-profit or not-for-profit. Ultimately, the duty to accommodate is the handmaiden to profit and organizational success. It is not their adversary. The other benefits of the duty to accommodate are that the measures we take to accommodate people with disabilities quite often have side benefits, unintended benefits, that help others. Where there are steps, that impedes somebody with a wheelchair. It also impedes somebody with a baby stroller or a shopping cart or suitcases on wheels. To the extent that we make a premises accessible, like a restaurant, by putting in a ramp instead of 2 steps at the front door, that accommodates people with disabilities who maybe use a wheelchair or a walker and want to come in to eat there. But it also facilitates people with shopping carts, baby strollers, or suitcases on wheels being able to come to that restaurant. It also reduces the risk of people tripping on stairs, or eliminates it, and therefore sustaining injuries and liability on the part The other major benefit of the duty to accommodate, it's a more subtle one and a longer term one, but it helps us displace stereotypes that too often in the past have pervaded about people with disabilities. The old way of thinking about this had been, let's go educate the public about disabilities and that will raise awareness and that'll change their practices. Unfortunately, sometimes that helps, but too often it doesn't. What we found instead that works is if we change people's practices, that changes their attitudes. If you get people accommodating people with disabilities, making sure they're included in their places of employment on a footing of equality and amongst their customer bases and so on, then as people get used to us all being part of the mainstream, that changes attitudes towards us in a positive direction. Now, next topic I'd like to focus you on, but briefly, is what disabilities are we talking about? Well, the duty to accommodate in human rights legislation, where it's spelled out, or even when it's not spelled out, and in human rights and in the Charter of Rights, applies to a broad spectrum of disabilities. People whose disability may be a physical disability, like people using a mobility device like a wheelchair or walker, people with a sensory disability, someone who's blind like I am, or someone who is deaf or hard of hearing or low vision, somebody with a communication disability, somebody with an intellectual disability, learning disability, somebody with autism or other neurological or developmental disabilities, somebody with a mental health condition. There's a very broad definition of disability, either in the legislation itself or in the way courts have applied these laws. And it includes both people whose disability is visible. When I walk down the street, I have a white cane. If you can see, you know I'm blind. And many people whose disability is invisible, like somebody with epilepsy or diabetes or certain other conditions, which are not visible at all to someone who's looking. It also includes disabilities that are permanent or disabilities that are temporary. And the Ontario Human Rights Code provides an interesting perspective on this because it also applies to people who are believed to have a disability. So if someone discriminates against you because they think you have a disability, it turns out you didn't, they were wrong, they're still liable under the Human Rights Code. Now, what kinds of things can accommodation include? I'm going to give some examples, but there is a broad range of things that could be included. In the area of employment, for an employee with a disability or job applicant, this could be providing people with adaptive equipment or support services. In the case of someone like me who is blind, if I go to work at your office and you have provide computers, I may need a screen reading program to read what's on the screen. Blind people who use Braille may need a Braille printer or other devices to interact with Braille. Support services can include attendant care. It can include somebody who uses sign language, might need sign language interpretation. It may involve added secretarial support or other clerical support beyond that which others might need. A second kind of workplace accommodation is altering the workplace. It may mean adapted furniture. If the workplace has physical accessibility barriers, it may mean adjustment to the workplace. It can also include working at home, as we've now learned through the COVID pandemic that is something that can be readily facilitated. It is something that we would be an important accommodation for any number of people with certain disabilities. The next kind of accommodation in the workplace can be changes in the essential work duties of a job. The way the Ontario Human Rights Code puts it, and perhaps it's more explicit than some others, is that the duty is to accommodate people with respect to employment and assessing and ensuring that where they're able with appropriate accommodation to perform the job's essential duties. An employer might find that a person, because of their disability, can't do some of the duties of the job, but if they're not essential to that job, the employer might reassign those non-essential duties to other people and reassign different duties to the job of the individual with a disability. We don't just simply take the job spec on its face as a locked-in fixed thing that cannot be changed. Let me go to another kind of workplace accommodation, and that can be shifting the hours of work and shifting whether the work job is full-time or part-time. Some people cannot work without certain rest periods, so we may need to adjust their hours. Some people may need dialysis, so they need to be away from work for certain periods of time. Some people, by virtue of their disabilities, may simply not have the stamina to work full-time, and so an accommodation might be providing them with a part-time work opportunities. Let me turn to the area of services. Accommodation, the duty to accommodate people with disabilities in connection with services. Now, the overwhelming focus of the case law and the cases that have been brought to human rights tribunals and so on in the duty to accommodate context for years has been in the area of jobs and employment. But services, access to services can be very important too, and there is a duty to accommodate. Let me give you just some examples. The same kinds of accommodations I've just talked about could be among them, but here's one. Public transit. One accommodation that I ended up having to fight for in a case called Lepofsky versus Toronto Transit Commission was to get the Toronto Transit Commission to consistently and reliably have its buses, streetcars, and subways audibly announce each and every stop as they are arriving so that I can know where I am. Sighted people can look out the window and see what stop they're at or read signs in a subway station, but I can't. So the accommodation for me that I was successfully able to argue for was an audio announcement of route stops. Now, since winning that, the Toronto Transit Commission has also provided technology to visibly announce those stops for the benefit of people on a bus or subway or streetcar who are deaf and can't hear the announcements. Another example in services is for people who are deaf and who need sign language interpretation. In a famous case in 1997 in the Supreme Court of Canada called Eldridge versus British Columbia, the Supreme Court of Canada held that a province which provides a hospital has a duty to provide sign language interpretation for deaf patients who need that accommodation to be able to effectively communicate. In that case, it was a deaf woman who came to deliver, who was pregnant and went to a hospital emergency room to give birth prematurely, and she needed to be able to effectively communicate with her doctors in the emergency room, but they didn't provide sign language interpretation. Supreme Court of Canada said there, under the Charter of Rights, there is a duty to accommodate her. Yet another example for services that you might want to contemplate is providing accessible premises to obtain a service. Where a chiropractor in Ontario had an office that was in an inaccessible location under the Ontario Human Rights Code, they were found to have violated the Human Rights Code by discriminating because of disability. Similarly, for a restaurant that's got an inaccessible premises can be exposed to possible claims under the duty to accommodate. Now later I'm going to talk about the limits on this duty, but I'm just now talking about what kinds of accommodations might be considered. For students, there's a whole spectrum of accommodations that might be needed for students with disabilities, whether it's adaptive technology in the classroom, it's added supports in the classroom, alternative ways they get exams, changes to their curriculum, obviously physical accommodations in the classroom, and so on. Our education systems are supposed to provide an individual education plan to students with disabilities, though that legislation is dated, at least in Ontario, and needs substantial reform because it doesn't fully meet the requirements of the duty to accommodate. For any organization that has websites, whether it's a place of employment or it's a place that offers goods or services, An accommodation that people with disabilities can need is to ensure that the website is set up in a way that will operate with adaptive technology that people like me use so we can read what's on the screen. And that involves ensuring that accessibility features are built into the website design. With respect to products, what about products? Well, this hasn't been litigated anywhere near as much, but it is a very fruitful area for more law to be developed, and soon, I hope. In this area, for example, many of us use a smartphone. I use an iPhone. It includes a number of accessibility features that are built in. If you go to settings and you look down to accessibility, you'll see you can turn on a screen reader to read aloud for those of us who are blind. It's called VoiceOver. You'll see there are adaptations for people with hearing loss or who need large print or any number of other accommodations. This is an example of meeting the duty to accommodate in the design of the product. Ultimately, our goal is for products to be designed in a way that meet everybody's needs. That is called universal design or inclusive design. Now, let me turn to the content of the duty. We've talked about who would have to comply with the duty. We've talked about what the duty, examples of what the duty can include and what disabilities are covered. But now let's talk about the content of the duty. It applies to all aspects of the relationship between the individual with a disability and the organization they're dealing with. So in the case of an employer, it goes through the whole employment cycle. There's a duty to accommodate at the job application and interview stage. There's a duty to accommodate throughout the job life cycle. Similarly, if it's dealing with a store or a service, it's a duty to accommodate throughout the relationship, not just getting in the front door or getting out with your product. And at its core, I'm going to talk about the legal concepts that are at the root of it in a minute, but I think for anyone who is the provider of employers of employment or of goods or services or facilities to the public, it's best to think of you as of yourself as having a duty to create a welcoming environment in which people with disabilities can seek and obtain accommodations. I'm going to talk more about how to do that throughout this talk, but think of that as an overarching thing. If people think this is something that is welcome, that is available, that you aim to please and you aim to help to the extent you can, that is going to help you achieve success. The duty to accommodate at its core does not, might be seen by some initially, way back when this started, as seeming to run afoul of equality principles, because people early on thought equality just meant treat everybody the same. Hey, duty to accommodate, that may involve treating people differently. Well, that's absolutely right, because at the core of our understanding of equality now, treating everybody the same is not necessarily equality. There are times it can actually be the problem. If you have a couple of steps to get in your restaurant and say, we'll serve anybody, come on in and we'll serve you, that's treating everybody the same. But for people with mobility disabilities, it's really saying you can't come in at all. So, what does the duty to accommodate mean? Well, think of it as having a couple of core components. The first component is the substantive duty to accommodate. It's a duty to actually take the steps needed to ensure that the individual with a disability can fully participate in employment or goods or services or facilities that you offer. Think of it as a duty at this stage first to identify and remove any barriers, any disability barriers that we get in the way, so that they can fully participate to achieve the purposes I outlined earlier. And I gave you examples of how that might be done, the kind of measures that an individual may need. But it goes further. It also includes a duty to prevent the creation of new barriers in the future. An example of this is a case called Via Rail versus Council of Canadians with Disabilities, or CCD, a Supreme Court of Canada case. In that case, Via Rail decided to buy a whole bunch of new passenger train cars and put a bunch of existing ones out of service. But the Council of Canadians with Disabilities showed that a bunch of the new cars they were buying had actually more barriers, were less accessible than the ones being put out of service. So what Via Rail was doing, in effect, was creating new barriers. And the Supreme Court of Canada said that the Canada Transportation Legislation's Equality or Human Rights Clause doesn't allow that. That is a form of discrimination. So you can't just create new barriers and then say, oh, later on we'll just worry about fixing it. Part of the duty to accommodate is preventing the creation of new barriers. Now, these principles, preventing new barriers, removing old barriers, are also at the core of our new accessibility laws, the AODA I referred to in Ontario, the Accessible Canada Act federally, and in British Columbia, Manitoba, and Nova Scotia at the time of recording. But it's core to human rights. The duty to accommodate is, this duty is not frozen in time. It's not just a once only, and it's done. Circumstances can change so that a person who didn't need an accommodation before might need one now. A person who hasn't needed one before might need a different one now, might not need any. But it's a living obligation. It's not a once only, all done, and then we're done. That's the first half of the duty to accommodate, the substantive duty. The second half, and it's an important one, I'm going to give it a bit of a fancy name, is the procedural duty to accommodate. This is a duty on the part of an organization if they're having any trouble doing an accommodation or figuring out what to do. It's a duty to effectively investigate solutions. In the face of a request for accommodation or a known need for an accommodation, if they can't solve the problem, they have a duty right up front. If they go, oh, no, I don't think we can do what you were asking or whatever, then they have a duty to investigate to see if their concerns are legitimate or if there are other alternative solutions. You can be liable under human rights legislation. You can be held accountable if you violate the procedural duty, even if it turns out that there was no substantive accommodation feasible in the end. In other words, if an employer, for example, just refuses to accommodate, flat out, won't discuss it, that's it, but doesn't take any effort to investigate it, they violated the Human Rights Code just by not even trying to figure out a solution, even if in the end it turned out no solution was practicable. Now, the difference there may bear on the remedy you get, but the procedural duty includes such things. Let me just give you an example. There was a case some years ago where a student with autism wanted to bring his service animal, his autism service dog, to school. The school board didn't want to allow it. Now, the Human Rights Tribunal rejected the claim, but I've written an article saying I think they were very seriously wrong. In this case, there was no showing that the school or the school board ever looked to other school boards that allow autism service dogs to see how they worked out. And there are other schools where they have been allowed and where it did work out well. The procedural duty would require that kind of investigation, if it's properly understood, before you say no. I'm proud of the procedural duty to accommodate. This is because I came up with the idea about 30 years ago in a law journal article I wrote, and the Supreme Court of Canada, I'm very proud to say, quoted it with approval and made it part of our law. So it is now part of the human rights law of Canada. And it's cool to have had the opportunity to share an idea and for it to catch on. Now, before I go further and talk about possible defenses, let me just get rid of some red herrings right out. I've already told you that not to get caught up with concerns about, oh, this might be treating people differently. That's exactly what it is, and the Human Rights Code requires it. Don't try to parse differences between what's an accommodation under the Human Rights Code as opposed to what is accessibility. These are overlapping concepts. It will get you nowhere to try to get into that. Accommodation helps achieve accessibility. Accessibility helps achieve accommodation. The other thing that's fortunate I can save you some trouble on, there used to be two different legal categories of discrimination: intentional discrimination, I don't want any people with disabilities here, or unintentional or adverse effects discrimination, just having a requirement that turns out to be discriminatory even though nobody intended it. It turns out that the Supreme Court has gotten rid of those distinctions, and for practical purposes, in both cases, there's a duty to accommodate. So you don't have to worry about those old legal labels at all. So when does the duty to accommodate arise? The old view was that it only arises when a person with a disability asks. And it's clear once a person with a disability asks, the duty does arise. They've put the employer or the provider of goods or services on notice. The clock starts running. And if a person with a disability is well advised, if they're asking for accommodation, to put their requests in writing, explain why they need it, because it is then easy to document when they asked and how long the clock's been running. But it's not good enough anymore to simply say, oh, that an employer or a service provider and so on can just sit on their hands and assume there are no accommodation needs until someone asks, because disability is so pervasive, and because with accessibility legislation like the AODA and the Accessible Canada Act out there, employers, service providers, and so on can reasonably be expected to know or learn more about this. They can't simply perpetuate a world full of barriers and indeed make it worse, because there is this duty to prevent new barriers, at least insofar as known recurring barriers. If a restaurant were to renovate itself, had no steps, and installs new steps, they don't, before someone comes along in a wheelchair and says, hey, I want to be able to get in here and I can't, the employer, the restaurant can't plausibly say, oh my gosh, we never thought of that, and heck, come back in a year. And then the clock may start running after the first request was made. No, I think realistically, where we're talking about recurring, easily foreseen disabilities, that there is some more expectation that the duty is out there even before there's a request. Now, that may affect the remedy to be ordered, and who can seek a remedy and so on, but I'm not going to go into that detail here. Next question. If a person makes a request, says, I have a disability and I need this accommodation, the employer or the provider of goods or services might want to consider, can I ask? What can I ask? Can I ask for medical documentation and so on? I'm not going to go into all the details on this. The Ontario Human Rights Commission has posted some excellent policy papers to give you more input into this, but I'm going to give you a few ideas. If it's obvious, you don't need further proof. If somebody walks in using a guide dog or a white cane and is demonstrably visually impaired, you don't need proof of from an ophthalmologist, I would argue, before you can accommodate them. The TTC did not ask me for that kind of proof before in connection with my request for stops to be called out on buses or subways. We fought over a million things, but we didn't fight over that one. As well, to the extent that you would ever have to ask for information about the disability, and again, I refer you to the Human Rights Commission's policy work on this in Ontario, the Ontario Human Rights Commission's website, but at the very least, I'm going to tell you that you should be asking the least information absolutely necessary, the least medicalized information, and it should also be shared with the fewest people on an absolute need-to-know basis while respecting individual privacy. Let me now turn for the rest of our time together to talk about defenses. This is the right to be accommodated, the duty to accommodate is not absolute. In the Human Rights Code language, it is up to the point of undue hardship. And I want to talk to you about what that means and how we figure it out. But in any analysis of undue hardship, there are three questions that need to be considered. The first is, what were the actual reasons for a refusal to accommodate? The second is, did those actual reasons bear out in fact? Are they factually founded? And the third is, if they were factually founded, are they legally sufficient to constitute undue hardship? This is focusing principally on the substantive duty to accommodate, but more about all this later. I want to explain at the outset about this business about what were the reasons. The reasons that if an organization is going to refuse to accommodate, it's fair to expect that they're going to explain why. And that the reasons they give at the outset are the ones that they will be judged by. If they try later on, years later, if they get lawyered up and a lawyer tries to come up with some clever new argument that they never used, it's fair for anybody who evaluated those claims to say, well, if it wasn't something wasn't an actual reason you were driven by at the time, you can't come forward with it later. It's hard to take that seriously. It's hard to see it as a good faith reason, rather being an after the fact concoction. So, and that rationale helps motivate employer service providers or others to actually apply their minds at the time of the accommodation request to what the reasons are, and to really give it a good hard look and a hard think through before they make the decision. Now, on a few general principles that govern the undue hardship defense. The respondent, the company, the employer, the government organization, the service provider, they have the burden of proof to show undue hardship. It is presumed in law that accommodation is doable. And their burden is to show that it would have been impossible to further accommodate the individual without undue hardship. Why does the respondent have the burden of proof? Well, there's several reasons. First is, they typically have the evidence and they know their reasons. And the second reason is that any other view would presume that it is impossible to accommodate, and that is completely inconsistent with principles of equality. If we sort of presume people with disabilities generally can't do things, and that if they want to do things, it's too hard to accommodate them until they prove otherwise, that would be a horrendous legal burden on vulnerable, disadvantaged folks, and it would fly in the face of the very notion of equality and individual dignity. The other reason that we place the burden on the employer or provider of goods or services is because our Supreme Court has told us that when it comes to human rights laws, which are quasi or near constitutional in their dimension, the rights they guarantee are to be understood and interpreted broadly and liberally, whereas the defenses, like the undue hardship defense, are to be interpreted strictly and narrowly. We don't want them overinflated. Now, you may have heard the term reasonable accommodation and think, well, isn't undue hardship just, was it reasonable? Answer, no. The term reasonable accommodation has been used kind of as a term of art, but the defense is not, was it reasonable, which would be kind of open-ended and mushy. The actual defense is, it was impossible to do any more, whether substantively to meet their needs or procedurally to investigate solutions, without causing undue hardship. The Supreme Court has told us that the duty to accommodate by virtue of undue hardship means doing more than trivial amounts, means taking serious and substantial efforts. It expects that, in the very term undue hardship, presupposes that some hardship is due. Now, the accommodation that is delivered need not be the best possible Cadillac accommodation. It's open to an employer to identify, for example, the least cost accommodation that is effective enough to meet their needs. And if they do, that is sufficient, and if it fulfills the goals of the duty to accommodate. Our one important principle as a practical matter that I want to encourage you to consider is this. At the core of making the duty to accommodate work is flexibility and a being ready to do trial and error. If an employee or a customer or a student or a patient want a particular accommodation, if there's some reluctance, give it a try. Consider if it can be done to do a test period or a trial period. It would be, unless the employer or service provider or someone can prove that even doing a trial period would cause undue hardship, then the duty to accommodate includes the idea of some trial and error or some trial period. It's been the experience, certainly my experience, and that of many people with disabilities and many who've done served as employers and providers of goods and services, that overwhelmingly, if the employer or service provider takes a can-do attitude, takes a positive attitude, say, like, let's figure out how to do this, that most of the time they're going to figure it out. If not at first, they'll work it out. If, on the other hand, there's a more rigid, bureaucratic, well, we can't make exceptions for you, and that kind of don't make us change the way we do things attitude, then that kind of entrenchment tends to get in the way. And what we end up with is not whether they can accommodate, but whether they're really willing to accommodate. There's been research over the years to show, particularly in the workplace, that most accommodations for employees with disabilities cost little or nothing. And that practical reality can infuse or inform our understanding of this. That's not to say there can't be situations where more costly accommodations are needed, but it is important to understand that is, as a starting point, that's kind of the reality out there. Now, what kind of proof is needed to prove undue hardship? Supreme Court of Canada has, many years ago, I think about 40 years ago, held that in defenses to human rights cases, it's important to present evidence, objective evidence, not impressionistic or speculative evidence. It's not enough for someone to go in a witness box and say, well, I don't think you could do it, or we thought about it and it just wouldn't work. They need to be able to provide some fact-based support for it that can be tested. With respect to this, it's also important to understand that accommodation is not once only frozen in time. If an employer or other organization said, well, we can't do that right now, but the question may be, well, could you do it in 2 months or in 3 months or in 5 months? It's not a matter of it now or never, and that's it typically. It's much more dynamic. And it's also important that deliberation on the accommodation request be not only bona fide in the sense that it's being sincere, but that it's free of exaggeration. If there's a situation where the argument is made that, oh, it'll cost too much, and the costs are exaggerated, that may lead an adjudicator, a human rights adjudicator, or a court to say, hey, that's not such a sincere defense if they're exaggerating their figures. And it's important in the world where we folks with disabilities live, there are some people, a reducing number of people, who just have a stereotypical assumption that disability costs too much, accommodating us costs too much. If that infects the decision making within an organization, first, it's going to hurt the solution finding. And second, it could well expose the organization. Now, let me turn to a couple of the criteria that are most commonly argued for undue hardship. The first is cost. An organization can try to argue that the cost of providing the accommodation would cause undue hardship. It would be impossible to accommodate because of the cost of it. Now, here are some principles that apply. First, the defense is not one of business inconvenience. They can't say, well, it's inconvenient, it'll cost us something. That's not a defense. They need to show that the actual cost will cause an undue hardship to the company or organization. This cost expectation on an organization will, of course, vary depending on the size and resources of the organization. We expect more of IBM than of a mom and pop corner store, by far, and properly so. We assess the lowest cost option. So when I wanted TTC to audibly announce subway and bus and streetcar stops, one of the options that was at least raised was the TTC buying fancy computer equipment to automate stop announcements. And that's what they ultimately did. But I argued that they don't need to do that, that every bus has a driver, every driver has a mouth, and hopefully they know what stop they're at. It costs nothing for them to announce stops. So that is what that option is the one to which the undue hardship test should be applied. Now, in fairness, the TTC did not argue that the cost of installing that more expensive technology would be an undue hardship. I don't want to impute that to them. Now, looking at the cost, it's important to not just calculate the cost through objective evidence, though it has to be provided through objective evidence. And not only that it must be the lowest cost option, but we have to look at what the net cost is. And the net cost means the gross cost minus a couple of things. First, if there are outside sources of funding available, those can be deducted off of the cost of the organization because they're not actually having to pay it. The second is, if it's a for-profit organization and these expenses are tax deductible, then we should be looking at what the after-tax cost is, not the before-tax cost, the net cost. And finally, we should deduct from the costs any benefits to the organization that are economic. So, for example, remember I said earlier, what about a restaurant that had a couple steps in front? Let's say they put a ramp out in front instead. Let's say it cost $500. I'm making up numbers. Well, would the cost of that ramp be an undue hardship? If it's a for-profit business, we'd say we deduct that cost from their revenues. For tax purposes, we need to know what their net taxable impact would be. Excuse me. But that's not all. By putting that ramp out front, they're going to get more customers. They're going to get customers with wheelchairs. And they're also going to have those customers with wheelchairs bring in other customers who are walking people. If I'm out for dinner and I can walk with a friend in a wheelchair, I'm not going into a restaurant with two steps in front of them. I'm not going to turn to my friend and say, hey, I'm going in there to eat dinner. You have a nice time. I'll see you when I'm done. We're going to find one that we can both go into. The restaurant that has two steps is losing both of our business. Put in a ramp, you're getting both of our business. You're also getting the business of people with baby strollers or shopping carts who didn't want to push them upstairs. That ramp may pay itself off, and it may pay itself off relatively quickly. If so, then its cost cannot be raised as a basis of undue hardship. Now, the next thing about cost, this is really important, and for many in the organizational settings like government or big companies, it may be something that they hadn't applied their mind to. The cost is measured as to whether it is an undue hardship to the entire organization, not to a particular office or department. So if I'm working in one particular office in the Ontario government where I used to work, and I asked for an accommodation, and they were actually quite good at accommodating me, I must say. But if they had said no, the question is not whether they could afford it within the budget of that one little office. The question is whether it would be an undue hardship to the entire Ontario government. Otherwise, an organization like the government could simply subdivide itself into a million little offices and say, oh, any accommodation, undue hardship to everybody. You can't allow that. Budgeting or bureaucracy barriers do not constitute undue hardship if the money is there. Now, moreover, if the cost of accommodation, even after all of those measures, is too much for right now, then we can look at the alternative of, Well, what if it's more than they can afford this year? What if we spread it over 2 years or over 3 years? The remedy that may be granted is an accommodation, but delayed in time. Two other thoughts about the cost issue. One is that when looking at whether costs are an undue hardship in a particular situation, the organization has to be expected to treat the costs as a priority item within their budget. If they say, well, we don't have any money because we've spent every last dime we've got and we just have no budget left, it's open to a lawyer to question what other priorities they have. In one case, I actually had a large corporate respondent who was opposing the duty to accommodate on a cost basis, not in a disability contest, but in a religion contest. And I asked them to tell us how much they spend per year on Blue Jays tickets, because clearly meeting their human rights obligations should be somewhat greater priority than their wine and cheese budget or Blue Jays tickets. The last consideration I want to offer you on costs is I want to suggest to you a different approach would apply when we talk about the cost of preventing new barriers as opposed to the cost of removing existing barriers. Everything I've set up to now is working on the assumption that someone needs an accommodation and it costs, and the cost is related to removing an existing barrier. If, on the other hand, an organization goes and creates a new barrier already alive to the disability need, then it's my view that they can't, consistent with human rights principles, say that, oh, after we create the new barrier, the cost of removing it later is an undue hardship, so we're off the hook. Because that would basically reward conduct that flies in the face of the Human Rights Code, if not wantonly lacking in any due diligence or care when it comes to human rights. Typically, preventing new barriers costs little or nothing, and it typically costs way less than removing them after they're created. If an organization with its eyes open creates new barriers, it should be expected to fulfill its duty to accommodate by undoing the mess it created, unless it can show that the cost of preventing them before they ever happen was an undue hardship. Now, another heading for another basis for that I'm just going to talk about very briefly for undue hardship is health and safety. An argument that an accommodation that is sought would create a health or safety risk. Just a few thoughts. All the principles I've just offered you about burden of proof and requiring objective proof all apply here. When health and safety concerns are raised, they may be raised because it is alleged the accommodation will endanger other workers, or that they may endanger the worker with the disability. These need to be viewed separately and differently. The danger to other workers, we got to look at it and apply the burden of proof and apply the principles I just gave you. But as for the danger to the individual themselves, the person seeking accommodation, there's a human rights principle called the dignity of risk. I, as a person with a disability, have the dignity to choose if I want to assume that risk. And it's not for an employer to say, well, we're not going to let you even try because we think it's risky, even though you are prepared to assume that. It's different when it's the individual themselves for whom the risk is created. Next possible heading or basis for undue hardship that has been raised in the past is the morale of other workers. If we accommodate you, that may get the other workers upset. I would argue that under human rights law in the year 2021, this argument likely is incapable of being plausibly asserted. It isn't specified in the Ontario Human Rights Code for Ontario cases. There is some decades-old case law from the Supreme Court of Canada that raised it as a possible ground. I would argue that things have changed since then. The idea, human rights aren't subject to a plebiscite. It's not a matter of we'll accommodate this worker unless other workers get upset. And even if an employer or service provider wanted, or well, this would really be only in an employment setting, want to argue that somehow the morale of other workers would be affected, to constitute an impossible to accommodate without undue hardship, they'd have to show that the morale objections are not tied to attitudes antithetical to the Human Rights Code. They would have to show that the risk is so clear and present and it cannot be rectified by an employer effectively educating their workforce to explain why they're engaging in this accommodation and that it's essential to human rights. The chances of an employer ever being able to prove that and show that even in the face of all of that, the morale problems are so severe as to constitute undue hardship, well, good luck ever trying it. I think it's better to treat this as a bygone concept that no longer has viability. What about collective agreements and unions? Now, often, as I said earlier, collective agreements will include a non-discrimination clause, so it will be an employee and union member may file a grievance saying the employer failed to accommodate them, and the union actually prosecutes the case for them. Now, in some cases, a small number of cases, a worker in a unionized shop will raise an accommodation request, and it's not just that the union doesn't pursue it, but that the employer and or the union actually actively oppose the accommodation or don't effectively facilitate it when they should. There is case law from originating about 3 decades ago, and I was involved in some of that case law as counsel, where claims may be brought in a unionized setting against the employer and against the union. Let me not get into the complexities of it, and let me suggest that principles that were articulated 30 years ago may again be refined in light of subsequent development in human rights laws, refined in a way that it gives stronger protection to the duty to accommodate. But let me just say this. The overall principles that do apply, the employer still has the duty to manage the business, but anyone who helps create a barrier has a duty to help relieve the barrier from creating discrimination against a person with a disability. So if the barrier is in a provision of the collective agreement, there may be a requirement on the part of the employer and the union to work together to remove the barrier that they jointly created. They cannot contract out of their requirements under the Human Rights Code. No one can. At times, they both have simultaneous duties to accommodate. At times, it is only the employer. It can vary. The Human Rights Code prevails over all other laws and all private contracts. The best way to approach solutions to this involve these steps. First, it is important for the employer, the union, and the individual to get together in a three-corner meeting as soon as possible to find a solution. It is really important for the employer and the union to try to resolve such issues without getting the worker either thrown back and forth like a football or put in the position of having their issues tied up with other collective bargaining posturing between either the employer or the union. If they want to, typically they can find a way. And as one court put it in one of the cases I was involved, basically getting rid of discrimination is everybody's business. What about the situation of conflicting rights? What happens if accommodating a person with a disability might impinge on the rights of other people or the interests of other people? Well, the Supreme Court, the Ontario Human Rights Commission has an excellent paper on this. I'm just going to touch on a couple of basic principles. If there is an assertion of conflicting rights, the employer or service provider has an obligation to try to find a way to protect them all. They can't just say, oh, duty to accommodate runs up against somebody else's rights, so I don't have to accommodate. An example where I've seen this raised in discussion is when we talk about the issue of allowing an autism service dog to go with a child with autism to school. What if the teacher is averse to dogs or allergic to dogs. So find a way to work in the classroom to either keep a distance between the teacher and the student or switch to another class where the teacher doesn't have that issue. There's ways to solve it if we're clever. Now, moving towards wrapping up, I want to offer a few thoughts. First, let me take you on a quick tour through what I would call some complete loser arguments. Loser defenses if a duty to accommodate case is brought. First loser defense. I didn't want to treat people differently. As I said earlier, that's no defense. Loser defense number 2. We didn't want to set a precedent, i.e. if we do it for you, we might have to do it for someone else. A workplace is not a courtroom. School classroom is not a courtroom. Precedent, or as we call it in the law biz, stare decisis, is just not the rule there. But I don't want to set a precedent translates as I'm going to discriminate against you so that I might in the future discriminate against somebody else too, or I'm not going to accommodate you because somebody else might come along. It's no answer. An organization should accommodate an individual if they have that duty and if they have no defense. And if somebody else comes along and seeks an accommodation, deal with that on the facts when the time comes. Next defense that doesn't get anywhere. I complied with the building code, or I complied with the Labor Relations Act. A lot of organizations tend to be more familiar with their own collective agreement or the legislation that applies to them. Architects know about building codes, and employers and unions know about their collective agreement and Labor Relations Act. That's maybe where they're used to living. But the Human Rights Code, as I said earlier, is the fundamental law. It overrides all of them. And so it is no defense to say, oh, I complied with the building code, so that's all I had to do. Or I complied with the Human Rights Code. I complied with the Ontario Labor Relations Act. Next defense that'll get you nowhere, if somebody tries to raise it, we didn't intend to discriminate, or we have other employees with disabilities, or I have a disability. None of those are defenses. There doesn't need to be proof of an intent to discriminate. It's not even relevant. We've never accommodated before, and we didn't want it to be the first time. That's kind of like the precedent argument, and it's about as equally bad. Sorry, it's a bad time. We found that when it comes to disability accommodation, for some organizations, they're really open to it and quite flexible, and that's great. And for some, they find it's a bad time, and it can be a proxy for, they just don't want to change the way they do things. The duty to accommodate is about changing the way we do things. Our building's a heritage building. Heritage is no defense to accessibility and accommodation. We can't say that we have a heritage building and therefore, by virtue of the fact it's older, it's okay to discriminate. Now, there are regulations that are passed under the Accessibility for Ontarians with Disabilities Act regarding outside paths that may suggest something different. And frankly, in my view, those regulations are wrong as a matter of policy, and they're contrary to the Human Rights Code and would not provide anybody a defense. The Human Rights Code would prevail. I don't have authority to accommodate. There's another possible defense. If somebody goes to someone in an organization, they go, I can't do it. Now, that may be a defense for the individual might say I can't, but then they have a duty to bring the issue forward to someone who can. Take it higher up the hierarchy. We can't do it this year. As I said earlier, if the evidence were to show that that's an undue hardship, it may be a defense to doing it this year. But it doesn't mean that you can't be responsible because, or an organization won't be will be let off the hook for even considering doing it next year. When it comes to built environment, I got my property certified as accessible by the Rick Hansen Foundation. The Rick Hansen Foundation provides this private accessibility certification. My coalition's raised serious problems about the standards they use and the training for the people doing that. But even if, and it's our view, the Rick Hansen Foundation has no authority to certify anything. But even if the Rick Hansen Foundation says a property is accessible, doesn't mean it is. It can nevertheless have barriers, and they can give rise to human rights exposure, and a Rick Hansen Foundation certification is no defense at all. The other possible defenses that wouldn't work, one of them is, hey, the guy's blind, I offered him some Braille. Now, some people who are blind, you read Braille, but not everybody does. Some people who are deaf use sign language, not everybody does. It's important to work out the accommodation in consultation with the individual to make sure it meets their needs. Accommodation is most assuredly not one size fits all. Another defense that's a total loser is, I complied with the deadlines for removing that barrier and regulations under the Accessibility for Ontarians with Disabilities Act. The AODA on its face says that if it clashes with any other accessibility law, the stronger law prevails. And the timelines in the AODA, we've objected to them for taking corrective action because many of them are way too long. And the fact that you complied with the AODA is not proof that you complied with the Human Rights Code. It doesn't preempt the Human Rights Code. It doesn't really get you anywhere. Let me close with a couple of thoughts. Accommodation in the workplace is as dynamic as the workplace is. Workplaces are changing all the time. The workplaces of 5 years ago are nothing like they are now. And in 5 years, they're going to be nothing like that they are now as well. The technology we used 10 years ago, we don't use anymore. The technology we'll use in 5 years, we don't use now. Inclusion and accessibility and accommodation don't happen by accident. They happen as a result of careful planning, of a welcoming environment to allow people and to ensure that people can seek accommodation. Effective accommodation ultimately meets the needs of workers with disabilities and their employers and colleagues, service and goods providers, as well as their customers. Ultimately, in the end, the duty to accommodate is about achieving a society of creative flexibility. Creative flexibility is not only at the core of achieving the duty to accommodate people with disabilities, but it's at the core of success of any organization in the public and private sector. I hope you found this helpful. If you'd like to learn more, I encourage you to look at the website of our federal and provincial human rights commissions to learn more about the Accessibility for Ontarians with Disabilities Act Alliance. Please go to our website. It's www.aodaalliance.org. And you can go on the homepage and sign up to receive our email updates. Follow us on Twitter. I'm at David Lepofsky, DavidLepofsky, or at AODA Alliance. Thanks for watching. Stay safe. And I hope you found this helpful.